So it being 3 after, I'm going to go ahead and get started. Thank everyone for coming. My name is Pam Wilmot. I'm Executive Director of Common Cause Massachusetts. We are a nonpartisan nonprofit that advocates for open, accountable government and free and fair elections. We are celebrating our 50th year and have been active in the elections arena for a long time. So today I'm going to speak we're all going to speak very, very briefly and then take your questions. First, I want to start off with thank yous. We have a lot of people that contributed to this filing. First, before we kind of get into it, the Election Modernization Coalition is responsible for much of the law that was passed, and not all of our partners are part of this lawsuit, but I think they all deserve thanks for getting us to this point. The election modernization is Common Cause, MassVOTE, and Lawyers for Civil Rights who are on this call, but also the League of Women Voters, the ACLU Massachusetts, the Massachusetts Voter Table, and who else am I missing? MassPIRG, yeah. So we've been together for about 8 years and have had a lot of successes. But today, a lot of lawyers did a lot of work to get this into court in a very short period of time. And I need to especially shout out and thank them for all of that. From the Lawyers Civil Rights team on the call is Oren Selstrom. He'll introduce himself and Lawyers for Civil Rights a little bit longer, but also Lauren Maslow, Janelle Dempsey, Ivan Espinoza Madrigal, and Sophia Hall also contributed to this. And on the Ropes team, Patrick Roth, who wears many hats in this, but we'll say today he's here representing the firm that did a ton of work to put this together. Robert Jones, Andrew Bellis, Kevin Rich, Aaron Kelly, Ricardo Mullings, and I'm sure there were more. From my team at Common Cause, Grace Bennett is our legal intern who did a lot of the initial work on some of the memos to get this started. And of course, David Sullivan, who is a board member, a longtime election lawyer, and has the original drafter of this piece of legislation, and a great advisor and advocate as well as lawyer for all of the details. So thank you all, and I'm sure the lawyers may want to thank their own team too, but I wanted to make sure that we did that first. And of course, Christina Mensick, who's the assistant director at Common Cause, who helps keep all these trains running and provides a lot of thoughtfulness along the way as well. So, so I'm just going to speak very briefly, then Cheryl Clyburn Crawford from MassVOTE, and then Oren Selstrom and Patrick Roth, and then we'll get to your questions. We should have you out of here easily by 1:30. So first, I just want to say that Common Cause is very proud to be part of this lawsuit because we know that voting is a critically important civil right that is under a lot of assault in these times with COVID-19, and our ability to vote safely is at risk with the Secretary's refusal to send a ballot as directed by the law that we passed just a week or two ago. In reality, we don't actually know what his intentions are. However, there was a press conference that he held last week where he said he was not intending to send the mailing unless he obtained more money. That is not a duty under the law. The legislature and the governor have made it clear that they will provide funding. There is some funding in the works, and there's also sufficient funding provided by the federal government exactly for this purpose. But we can't have public officials picking and choosing what parts of laws they can adhere to, and particularly when it relates to voting rights. This is absolutely critical. We're facing one of the toughest elections in our history coming forward. Massachusetts is going to be moving because of COVID-19 from a very small number of mail ballots to 50, 60, 70% mail balloting. And voters need the opportunity to do that and to do that safely. We look forward to working with election officials and with our coalition partners and others to implement the law fully, thoroughly, and completely, and to educating voters as to their rights. So with that, I'll just turn it over very quickly to Cheryl Clyburn-Crawford from MassVOTE.
Hey, great. Thank you, Pam. So I am Cheryl Crawford, the Executive Director at MassVOTE. For those that don't know, MassVOTE is a nonpartisan voting rights issue advocacy organization founded in 1999 by a small group of community leaders to increase voter turnout, modernize our election laws, and engage the next generation of leaders. I am just absolutely, it's just unbelievable that we are having to bring this lawsuit today. We've been talking about protecting our elections, preparing for our elections at least since November. And quite frankly, I would have thought the Secretary of State would have been proactive around this issue, wanting to see our elections go as smoothly as possible, seeing that we have had the opportunity to look at elections take place all across the country and seeing the issues that they have had. So, you know, it was a great win. Thank you to the entire Election Modernization Coalition and the, legislators that really ushered this bill through to get us to the point where we will be having mail ballots. It's critical. It is going to have some very deep implications on the communities of color, communities with less income, new citizens, that if we don't have that, I'm thinking about, even though COVID has taken front and center, taken over everything, that we have to be paying attention to the most vulnerable populations. And in that, there are those people that do not have computers that won't be able to print the application and mail it back in because they simply do not have a stamp. For whatever reason there is, the Secretary of State should be doing what was passed, and that is making these elections as smooth as possible. We're talking 2 days out from the Secretary of State having to mail these applications out. That is a problem. So here we are.
Thank you, Cheryl. And before I go to Orrin, I just want to be clear that the mailing that is required in 2 days is a mailing of mail ballot applications. It is not actually mailing the ballots themselves. That happens after the application process. And sometimes I know there's a lot of confusion around that, and we just want to be clear that that's what we're talking about when we go to the mail. So next I'll turn it over to Orrin Sellstrom.
Thank you, Pam. Is my audio okay here? Great. So good afternoon. My name is Orrin Sellstrom. I'm the Litigation Director of Lawyers for Civil Rights. We're proud to partner today with Common Cause, MassVOTE, our pro bono co-counsel at the law firm of Ropes Gray, and our 7 brave individual petitioners to file this emergency lawsuit to protect voting rights in Massachusetts. Legally, the case is as straightforward as it gets. The law states that Secretary Galvin must mail vote-by-mail applications to all registered voters by July 15th. Secretary Galvin says he won't comply with the law. We are asking the state's highest court to order compliance. The legal claim is simple, but it raises profound issues of critical importance to our democracy during the current public health crisis. As our petition details, Secretary Galvin's refusal to comply with the vote-by-mail law will fall most heavily on those who are traditionally disenfranchised by barriers to the right to vote: communities of color, non-English speakers, and low-income individuals. Our diverse group of individual petitioners come from the Black, Latinx, and Asian-American communities. Their affidavits speak movingly of how they see voting as a privilege that they are proud to exercise. But at the same time, they are terrified by the prospect of being infected with COVID-19 if they go to the polls this fall. Many are elderly and with underlying health conditions, meaning that they are particularly vulnerable to severe illness or even death if they are infected by the virus. Simply put, if the Secretary does not comply with his duty to mail out vote-by-mail ballots and applications, our petitioners and many thousands like them across the Commonwealth will be unable to vote this fall because they will be too scared to vote. That's wrong. In America, voters should not be forced to choose between exercising the right to vote and staying safe. Secretary Galvin should perform his duties as the law requires so that all voters in the Commonwealth can vote safely. Our petition asks the Supreme Judicial Court to act on an emergency basis to ensure that all voters, particularly those who are most vulnerable, are ensured equal voting opportunity. Thank you.
Thank you, Oren. Thanks for all your work. And Patrick Gross from Ropes Gray, who's done yeoman's duty in getting this together over the weekend. Thank you.
Thanks, Pam. Thanks, everyone. I'm happy to speak very briefly. I think Oren really laid out the case, and Cheryl and Pam made the stakes clear. Oren's right. It's a straightforward case. You know, just as much as it's about protecting the right to vote, it's about the rule of law and ensuring that public officials, when the law says that they are obligated to do something, that they in fact do it. You know, it's disappointing that even during this time of the pandemic, where the government needs to work together to make sure that people's rights are upheld, and we're all just kind of swimming in the same boat here, that officials are still willing to put up obstacles to access and things that are going to be barriers to people when they try to go and vote and fall. I'll back up to the introduction. I'm a litigation associate at Ropes Gray, and I'm also on the advisory board of Common Cause Massachusetts. We are very proud to partner with LCR and with Common Cause Massachusetts and with MassVOTE. With me on the call are some of my colleagues from the firm, Rob Jones, Andrew Bellis, Kevin Rich, and it's a delight to be part of the team. We think it's a straightforward and winnable case that we expect the SJC will be interested to hear rapidly. And we look forward to working with everyone to get to the right result here.
Thanks, Patrick, and thanks to everyone. So let's take some questions now. If you have questions, please put them in the chat or raise your hand. You can raise your hand in your participant section. Or if you're on the phone and just need to chime in, just do that. So any questions? Oh, we've got one person to admit. Any questions? Chris?
Hi, this is Chris from the news service. If I can just jump in here.
Yeah.
Can you speak a little bit about why the timeline here is so important? Obviously, the law does explicitly state July 15th as the target, but say the secretary were able to get the ballots out by July 22nd. Does that still warrant a lawsuit? Why is it so important to hit this very specific date?
I will just say, from our perspective, what's important is that this mailing get filed soon. We did not wait until the date passed, which would have been on Wednesday. We filed today to ensure that it gets out as soon as possible. The law specifies the 15th. My understanding is that there were not objections raised to that date. It is clearly very close to right now, and if there was no intention to actually comply with the law, it would be very difficult to do it in the next 2 days. But performance of a duty under a law as our officials is not optional. And we need assurances that this is going to go out and is going to go out very soon. We are not that far away from an election. September 1st is just right around the corner. And not only do these ballot applications have to go out, then the voter has to fill them out, send them back. Then our election officials have to process those and then send another mailing back to the voter. And then the voter has to turn around and send that back. So we're not actually talking about one mailing. We're talking about a whole series of mailings and a whole series of duties. And our fear at Common Cause is this could be a slippery slope. You let, one thing pass, and what's next? Some of these other deadlines are not things that there is any room whatsoever. We felt this was absolutely critical, and we could not let this one go. I don't know if someone of our other folks or attorneys want to comment on that, but that's my take on it.
Well, just on the timeline, I think that's exactly right, Pam. And just remember that the legislature could have chosen to just send everyone an absentee ballot and skip that step of an application. And they didn't. You can agree or disagree with the conclusion, but they set up a system that requires some amount of time because it gives people the opportunity to decide whether or not they want to cast a mail-in ballot or go in person. And having that system work appropriately and giving all the local elected officials enough time to put it into practice and just to have voters have enough time to decide how they want to vote, it needs to start immediately, and it needs to start by the date on which the law says it needs to start.
And I'll just chime in and say that it's critical because we know that there's a digital divide. We understand that there's language access issues that we have to deal with. The sooner we can get this moving, we can start the process. And that's critical because we're going to have to get into these communities to ensure that they understand what this whole process looks like and the procedures and also, just educating them on the other pitfalls that could happen that I won't bring up here now, but there are other pitfalls that we could be facing. And we don't want this to be one of them.
Other questions? Chris, does that answer your question?
Yeah, that answers it. I'd actually like to follow up with you quickly for something you touched on. You mentioned that this lawsuit comes 2 days before the actual deadline. Why is it so proactive from advocates to file this before the actual violation of the law has occurred? Wouldn't your case be better if you waited until the 16th after applications didn't go out and the secretary was actually in violation?
Well, in reality, there won't be a hearing scheduled until after the deadline. So if the mailing goes out on time, then that's great. We're so much the better. Although, Oren, maybe you look like you want to jump in here.
Yes, I was just going to say, Chris, I think you used the right word, which is proactive. We want to make sure that the timelines are followed. And so waiting until after the deadline in order to then file suit would have meant losing precious time. We felt it was critical to act on an emergency basis to take this matter to the state's highest court and to ensure that the timeline was hewed to as closely as possible. And for that reason, we filed today seeking an emergency hearing. And our hope is that we will secure that and be able to get compliance from the Secretary of State's office, whether voluntarily or through a court order, as quickly as possible.
And just to state the obvious, I think is probably the premise, but if the secretary had said that he was at least intending to comply with law, I don't know that we'd be in the same position. He said the opposite of that, and he was fairly definitive about it from media reports.
Other questions? Oh, we had a couple people join kind of late.
Pam, I can see how there would not be a lot of questions. This case is so simple and so straightforward. It's simple, right? Like most people we don't have to do a lot of explaining because it's straightforward. It's simple. Do what you're supposed to be doing.
Do your job, yes. That is true. Well, I will give one more call, and if not, I will thank everyone for their participation. And did you have a question, Suzanne?
I am embarrassed that I joined this 20 minutes late, so you probably already addressed this, but I spoke with Deb O'Malley a few minutes ago, and she just said that that they're working on it, that the ballots have been printed, that they believe they can't use the money that's already been appropriated for this purpose, that they want the Senate to, let's see, she said the Senate passed it, but it has to pass some other committee in the Senate and then pass the House, and she doesn't know how long that will take. And she disputed the idea that they haven't brought this up prior to this. So again, if you addressed all this in the last 20 minutes, I apologize, but that's what Ms. O'Malley said when I called her.
Well, our brief does outline the reasons why, and it's very clear that the money that's already been appropriated can be used for this purpose by the federal government. Several other states have mailed ballot applications. The Election Administration Assistance Commission, said specifically that mailings and postage can be used for this purpose. I suppose it's good news that they're working on it, but it is not something that can be held hostage. This needs to go, and it needs to go out. Anyone else on the panel want to contribute to any answers on that, and then we'll wrap it up. Orrin, Patrick? No? Okay. All right. Thank you all. Appreciate it, and stay tuned.